Welcome back, everybody. Delta's back, COVID's back. And so we on the legal lowdown on the lockdown, takes me a while even to remember that phrase, are back to discuss what's happened legally since the re-emergence in all of our lives of COVID-19 and the legal problems that the new Delta variant has created for the New Zealand government and for all of us. Joining me today, I'm Jeff McClay. I'm a Professor of Law at Victoria University of Wellington's Law Faculty. Joining me are my colleagues, Nessa Lynch, Dean Knight and Eddie Clark, all of the Law Faculty. And also we've got a special guest from the University of Auckland, from the Koitu Centre for Informed Future, Andrew Chen, who will be commenting for us on some of the privacy aspects of the government's plans in relation to the COVID tracker app and the making it compulsory to enter various places around town, which is obviously, we think, one of the really hot button issues of the next couple of weeks legally, but also a matter of policy, because one of the things that's been really front and centre in New Zealand's response has been the desire of the New Zealand government to both be an effective public health regulator, but also one that respects people's privacy. And there's been conflict all around the world in terms of how you get that balance right. But what I was going to do to start off with is just to get back to my colleague, Dr. Dean Knight, who has been, and I'll use this phrase advisedly, train spotting for us the relevant COVID-19 orders. And maybe he can just set up how the legal framework is different this time from what it was last time. And we spent a lot of time discussing how unclear or ambiguous the legal law was. Perhaps one of the features, Dean, this time is how lacking in ambiguity some of the regulations are, or at least the source of the regulations is.
Yeah, thanks, Jeff, and kia ora, folks. I think if we look at the scheme and the sort of structure of regulations, it's not too dissimilar to what we had in March and April last year under level 4. But the aspects which have been sharpened, and before we go to the detail, it's important to acknowledge that last time we were in alert level 4, of course, the orders were made by the Director General under the Health Act, but in this instance, we've got orders that are made by the Minister for COVID Recovery under the COVID-19 Public Health Response Act.
Although, just to stop you there, Dean, because one of the things that we argued endlessly last time about who had the power to make these orders, Ashley or Chris or Jacinda or some combination of all of them, or Cabinet. And the COVID Response Act was very clear. It would be the Minister of Health and now the Minister of COVID Response who would do it. But I've been watching the press conferences and I've seen almost no mention, even by Mr. Chris Hipkins himself, of his powers. And he's referred constantly to Cabinet and referred constantly to Cabinet making decisions, when in fact the Act very clearly, in my view, makes it his decision what the orders are going to be. And it was deliberately set up so that it would be his decision, not Cabinet's decision.
Well, and I think that's the function of our sort of Westminster democracy when we look at our conventions around ministerial responsibility, is that there is individual responsibility reposed to ministers, but it happens within the collective context. And in this instance, the legislation actually specifically requires consultation with specific ministers. And there's also an expectation conventionally, to the extent the law allows, for a minister to take matters of importance such as these to their colleagues for their input, even if the ultimate decision still lies in the with the particular minister and the Minister for COVID Recovery in this instance.
So just to be clear, when Jacinda Ardern says, as she will say on Friday, Cabinet has decided that the following places will remain in alert level 4, we really understand that to mean Cabinet has advised Minister Hipkins that Mr. Hipkins shall make an order requiring the various places to remain in level 4.
Well, there's a subtle difference in responsibility, is that the Minister for COVID Recovery is required to take into account Cabinet's decisions on broadly settings, which we know is the alert level framework, which is where that decision is made. So, I mean, in the last 18 months, that whole process has been sharpened, and it's a lot slicker and much more sensible than that sort of delicate tango between Dr. Ashley Bloomfield and the Prime Minister and the ministers there, where all the power was reposed in the unelected official, but the politicians were sort of stage managing what's going on. So much clearer there. And I think probably the other thing we need to acknowledge is there's no question the legal underpinnings being at doubt here, as they were, and we debated a lot in relation to the Borrowdale litigation. This is the power to make these types of orders requires us to stay at home and spelt out in neon lights. That's not to say, though, that there won't be Bill of Rights questions which may not be live, because COVID orders need to be consistent with the Bill of Rights. And, the context in which these orders land mean that, I guess, circumstantial assessment of whether our mobility rights have been justifiably restricted will be different now than what was in play in March and April. But for myself, I don't really doubt that there's a foundation for the orders in this instance. Again, given what we know about Delta and especially its aggressive spread.
So the big remaining issue in the Borrowdale case is almost certainly going to be around the way in which we dealt with essential services under the previous regime. So can maybe just go through for people what's changed about the approach. I think clearly as a result of some of the angst that's been caused maybe by the Borrowdale case and some of the other experiences of the last big lockdowns.
Well, maybe I can dial back, Jeff, just slightly to say, structurally, we have the four key main elements that we saw, not dissimilar to what we had last time. The stay-at-home direction with some exceptions, and I know a couple of other folk want to talk about that. The closure of the premises except what are now called alert level 4 businesses and services. So that's, and I'll come back to that one, a physical distancing requirement now no longer with a temporal 15-minute trigger and a prohibition of gatherings. And as you say, that there's a lot of sweat about what are the exceptions, both in terms of stay-at-home direction, where we can go out for essential personal movement or limited recreation purposes, what's readily accessible, and I know some other folk will talk about that. In terms of the closure of premises and who can operate and what premises could be open, rebranded approach here rather than essential businesses. We've now got alert level 4 businesses and services in comparison to last time we had essential businesses. Last time, what was essential depended on a definition necessary for the provision of the necessities of life, as detailed on an MB website. And a lot of the Borrowdale litigation about was that's just really confusing and seems to delegate the decision of what qualifies as essential to officials and so forth. In the High Court in the Borrowdale case, they kind of said we don't really care about the website, or the website was redundant. So it all depends on what's necessary for the provision or essential for the provisions and necessities of life, which is an abstract sort of definition which is open to debate, and we'll see more out of the Court of Appeal shortly on that. When I think they're going to take a different approach in the High Court. I mean, to fast forward, this time we don't have the lack of clarity because we've got a schedule which lists out the specific categories of and types of businesses which qualify as alert level 4 businesses and services. So supermarkets, dairies, food banks, licensing trusts, and other things like that. So and very good rule of law improvement here. We've got that specificity, we've got that certainty, but it's not necessarily fully stable. I see earlier this week on Monday, there was some very reasonably significant changes to the treatment of delivery of baked foods and other matters like that, where there's been an amendment to the schedule to specifically identify some types of premises which can continue to operate, and also
so to be clear,
what qualifies.
So just to be clear there, my understanding of the first version of the rules was that services like butchers could not home deliver. That was the drafting that I read. But that drafting's now been changed. Someone's realised that it probably wasn't what was meant. And it's been changed to make it clear that people like butchers and greengrocers can in fact home deliver. They can't run their stores in person, but they can home deliver. And they've done that through a change in drafting. It's one of those things that obviously the drafters thought they knew what they were writing, and they just didn't write what they probably meant to do. And in fact, none of the government guidance seemed to be directed towards butchers not being able to deliver or greengrocers not being able to deliver.
Yeah, two of the categories got run on together, and there was a sort of a qualification on the second part, but everybody read to the first part. But it's been spelt out, and that's important where there's a lack of clarity. That moves might take in to sort of clarify what are the policy setting. I guess the other thing that's been of concern to some people is just that policy setting of not allowing people to visit grocers and butchers. And for myself, I don't have a problem with that policy setting, because it's, I think, informed not by saying that butchers and grocers are any different or similar to dairies or anything like that, but from an ideal or an aim to try and restrict the number of premises that people are going to and reduce that type of movement. So I understand the concern that of grocers and butchers, that they feel that they're not being treated even-handedly. But I think you've got to look deeper for the policy rationale of trying to minimise the number of premises that are open and being serviced and supplied.
And obviously, obviously they've thought about this for a while, and I think rather than necessarily an entirely principled shift from here's the description and officials will add things to the list that they think meets the description and principle, moving from that to this long list, I don't think it's entirely just we've decided to do this differently. I think they would have done what we have now the first time round, except it happened very close to overnight. And it's a question of drafting resources and how they could put it together. And what this shows, despite a couple of things that clearly needed to be changed or tweaked, as you just discussed, is that over the past few months, the drafters at PCO and the policy people at health and at police and various other agencies have been working quite hard to have the schedule ready to go as soon as there's a shift in alert level. So this is work that will have been happening in the background in preparation for this. And it does give us some more certainty, albeit not perfect certainty, because until the rubber hits the road, you don't know what's going to necessarily be at issue. And we've seen some things at issue here that perhaps the drafters didn't envisage, as you said, Dean.
But I think that it's absolutely right, Eddie. Obviously, there's been a lot of work been done behind the scenes. But what surprised me, and I think maybe Dean can comment on this, is what wasn't in that first order or what's been announced in terms of policy in the last week. So we're going to mask mandating, we're going to compulsory COVID tracing, app scanning, or whatever you want to call it. But that's not in the rules that were put out as soon as this emergency happened. And I find that a little bit curious. And I have to say that I found the iterations of the orders curious, because on the one hand, it's obvious, as you've said, that a lot of good work has been done, but some policy hasn't been done or hasn't been brought together when it needed to be brought together.
Jeff, I think for me, I think for some time many of us thought we'd never get back to alert level 4 and would be under at worst if we're at stay at home under alert level 3, which has obviously got a different policy setting around safety and more movement. But the advent of Delta, I think, changed that. And I think the government has rightly reverted back to that core idea of minimal movement, that it is lock it down and just keep going what we need to get through and get our head above water again. So I don't quibble with that policy setting and that type of restriction. I think what was going on with the mask mandating, the digital scanning, and maybe others can pick up on this too, is this it's different trains of policy work, because I don't think the mask stuff and the digital stuff was in the alert level, the lockdown thinking, and I think the government was going to announce or made decisions at cabinet, the day before lockdown on scanning and things like, was just about to announce it. So it's kind of the two streams of policy work coming together. So it's been a bit of a shaking down over the week on that.
And on the time frame regarding the mandatory record keeping policy, we first heard a suggestion that this is something that they might want to do back in January. And to my understanding, basically someone in cabinet thought that this would be a good idea and wanted the policy people to figure out how to make it happen. And it's gone round in circles a lot between all the various government departments. And there's been a lot of consultation on, does this breach privacy? Does this breach human rights? And for a while, it looked like it wasn't going to happen. And I think with the Wellington scare earlier in, I think maybe July or June, that was when it really ramped back up again. And that was what led to this decision that was supposed to be announced just before Delta came out.
But it strikes me as strange, like we've all seen the effect that these very big events in Auckland have had on the ability of contract chasing. And you can imagine, had they been all these people all been scanned in at all these events, as Ashley Bloomfield has said, there would have been a lot less burden. So it seems like it's interesting how the policy has gone here, that people have been maybe rightly concerned about privacy. I'm not really the world's greatest Privacy Act booster, but might have been right about privacy and human rights, but there seems to be a lack of other balancing in that process with the realities of what might happen if this situation occurred, which now unfortunately has occurred. And we've seen the contract tracing almost overrun.
And it's interesting to see when they want to push and what has led government to push that compulsion button as opposed to guidance. I remember when this was first announced, the first press conference on, we found this tradesperson in the Coromandel and in Auckland with a case. There were questions from the gallery about why the lockdown couldn't happen right away, why we had to wait until 11:59. And the Prime Minister very clearly said that it's because we can't just do this by fiat. I can't just say it and it happens. And that sounds like a bit of a legacy of the Borrowdale litigation to me, where the court said, you can't just say it. If you're making it sound mandatory, it has to be via law. And we've seen an interesting, in a much less dramatic sense than lockdown or not, the difference between those two with when masks are required, because we had it as a, not even really a recommendation because the science hadn't moved there yet, but if you feel uncomfortable and feel unable to distance, wear a mask in supermarkets during level 4. But now this time round, there's a legal requirement. There's a legal requirement to have the masks, but not outside. And they're relying on guidance for that, for when you're out exercising or out and about. If you feel that you can't keep physical distancing, wear a mask. And in the extremely anecdotal experience of walking around the botanical gardens in Wellington, the compliance among people walking and cycling is remarkably high, just relying on guidance rather than rules. And I think that this is what the government hoped would happen when they just had guidance for masks on public transport and then moved to a mandatory system when no one did it. I suspect the threat of an active Delta outbreak probably is as good a prod as a legal requirement, at least for mask wearing. But interesting to see that you must do this in supermarkets and getting essentially universal compliance, but getting very good compliance without that compulsion outdoors.
Yeah, and following on from that, Eddie, like I think we've still seen a bit of a mix-up maybe in messaging with the driving to exercise point. You know, and I agree, I've been really struck by that when I've been going on my state mandate to exercise, that mask wearing has become absolutely routine, and people actually do give you a bit of an evil eye if you're not wearing a mask. But I think the police let themselves down a little bit earlier in the week with some of that leafleting in Wanaka, I think, and other places about driving to exercise, because thankfully we haven't had rules here in this jurisdiction with a kilometre limit that we've seen in other jurisdictions. And I think that's been a good thing. But, you know, there has been some mixed messaging around whether it's actually banned to drive for exercise. And I think it's really important for legitimacy purposes to disentangle what's compulsory from what's, you know, something that's good to do. Because we don't want people congregating at beaches or other recreational areas, but we've still got people who have a real need to drive for exercise. So if you've got toddlers, tamariki in your bubble who need to run around somewhere safe, if you've got a dog that needs an exercise area, you know, if you've got somebody with limited mobility that needs a flatter place to exercise, those are all people that can drive for exercise. I was trying to run through this today when I was taking the car to the supermarket, whether I could bring the dog and take him to another exercise area, but I thought I wouldn't push it. But I think that's an important point, that, you know, places must be very clear on what's required and what guidance they're giving. And I suppose just another quick theme on police enforcement before we have a little bit more on the app, but bit of a sense that the police may be kind of escalating more to charges than they were at the start of things the last time. And I think, to be fair to them, Delta is a whole new game. And obviously the health advice we were getting this time last year or 18 months ago was much more around, you need to be in the presence of an infected person for 10, 15 minutes. Whereas now we know that even a fleeting contact has got a risk. So I think with that in mind, they have been really quite stringent on people who are breaking the rules in terms of protests. And, you know, Australia is being put forward as a cautionary tale in many aspects of this response, but we've seen those super spreader events in Australia. But of course, I think the same things we were exploring in our last level 4 lockdown, that it's really important that vulnerable people, you know, people with various capacity difficulties, don't get caught up in some of these real push towards compliance. Because I think another thing for me is that there's certainly a bit of a different feeling around, I think, than the last level 4. You know, there was a bit more of a sense of being all in it together last time, I thought, whereas I think there's a bit more of a impatience this time. So it's really important that we have that social cohesion, you know, and that we're being really clear around what's required and what's just guidance. But I'm going to hand over to you, Andrew, because I think on that theme of compliance, there's some really interesting developments in that area of the app use and the mandatory records.
Yeah, so I mean, it's important to note actually on that last point that it's mandatory record keeping. The government is being very careful to not say that it's mandatory use of the NZ COVID Tracer app. And there are 2 key reasons for this. One is that there's probably about 20% of adults in New Zealand who are still digitally excluded, who will not be able to use the app, either because they don't have a smartphone or they don't know how to use it. And so there has to be an alternative for them. And so signing in on pen and paper is accepted as an alternative to using the app. The second is that we use the Apple and Google Bluetooth protocol, and they have a very strict rule that you cannot mandate the use of their system. And so Chris Hipkins on Sunday said in response to a question that apparently Apple and Google are okay with mandatory record keeping of some form as long as it's not mandatory use of the app.
And in your view, is that actually a real distinction?
Yes. For the vast majority of us, hopefully we will be using the app because the digital nature of it will has additional benefits for the contact tracers. But there has to be a pen and paper option for those who cannot use the app for whatever reason.
Yeah, so if I can jump in there, you know, something really interesting that was on a newsroom piece earlier that I know you commented, Andrew, along with, you know, other people in our circle, but is about that concern around we have a collective interest in people using the app. So should we mandate some rules or perimeters around government and particularly law enforcement access to the app? So can you give us a summary on that? Because that's quite an interesting, you know, should there actually be a rule that police cannot access this data at all?
Yeah, so what we have at the moment is strong assurances from both police and the government and, you know, ministers and Ashley Bloomfield basically saying we won't use this data for any other purpose. Unfortunately, what's happened in both Singapore and in various states in Australia is that the data that was collected for contact tracing purposes has been used for law enforcement purposes, despite assurances that were made by both police and the government agencies there. And so while the risks are different here in New Zealand, because all of the data stays on the device rather than going into a centralized government database like it does in Australia and Singapore, there is still the risk that this data that we are collecting for contact tracing purposes could be misused, whether that's for law enforcement and by police. We also thought about tradies who might be doing cash jobs on the side who don't want to be caught by IRD. We were talking about beneficiaries who might, you know, if it gets found out that they're actually in a relationship with someone, then MSD will change the benefits that they get. Overstayers who might get in trouble with immigration, and that's government agencies. And then there are also potential misuses by employers, potential misuses by businesses who might take that data and use it for marketing purposes. And so all of this really, I mean, some of this is outside of the control of the government, right? And we're sort of saying, okay, assurances get you so far, but we really should have some sort of legislative protection beyond what is in the Privacy Act that says specifically data that is collected for the purposes of contact tracing should only be used for the purposes of contact tracing.
And a really interesting point, sorry, can I just do a quick one here, Jeff? Like something that I really like to throw out to anyone who's watching who's a real expert in the law of evidence, because I've had a bit of a back and forth with other colleagues on this today, is whether it would actually be possible for Parliament to pass a statutory prohibition on the use of a particular type of data just for law enforcement, because I just can't see how this would work in practice, because police can obviously get a warrant for your device. And it would seem to me a little bit strange that police could get a warrant for the rest of the data on the phone, but not the COVID tracer app. Like, I understand the general point about not allowing police and other government agencies access to the data, but in a particular warrant scenario, I'm not sure that that would actually be possible. Again, I'd be really interested to hear kind of what people who are more embedded in the law of evidence think. Because obviously police can get a warrant which will also give them quite detailed information about your location. So unless you're taking the battery out of your phone, essentially that information is there. So I think that's quite an interesting point that no doubt if this does go further, there'll have to be a lot of discussion on that point.
I will just add one use case there, one precedent there, which was in Australia. Intelligence agencies did have a warrant to get someone's smartphone, and that smartphone was running COVID Safe, which is the federal level app that they have in Australia. And the intelligence agencies subsequently realized that they were in breach of their data protection legislation, apologized, and deleted specifically that data from their repository. So they had access to the rest of the phone, but not that little bit. Of course, I'm not an expert in the law of evidence, so I'm happy to defer to others on what might happen in New Zealand.
Yeah, evidence law experts in the audience, please. Be interesting to know more about that. That's fascinating, Andrew. Thanks.
But also, it's curious that the government just hasn't come out and said that the policy will be that when we pass the statute or when we require this order, that we will put that in the order or we will put that in the statute. Because as Nessa said, you probably need to get a warrant anyhow to access the phone on which the COVID app is, because the information is not centrally held, Andrew. You need to get hold of the phone, right? You can't look up a database.
In most cases, yes. There is one exception, which is individuals who have tested positive for COVID. Obviously, they are providing their records to the contact tracers, and so that is sitting in a central database. But at this point, that is a database of maybe a few hundred individuals rather than all 5 million of us.
And it just seems strange to me as a matter of policy that they're not prepared to come out and saying that's what we will do. Because
it was quite odd. On Sunday for Chris Hipkins to basically say, we don't envisage this being used for other purposes, when he could have been a lot clearer.
So this isn't the first time in this rodeo in the last year, actually, because in a more obscure area in relation to trusts, which obviously very dear to my heart normally, there was a statute put through under urgency which enabled the commissioner to do research by requiring people to give them information about their trusts. And it was pointed out by many parties, including the Law Society, that was a search. And as part of it being a search, you need to put protections in place. And so what they did was they put a partial restriction on what that information could be used for, that it couldn't be used, to use your example, Andrew, to hit tradies who were doing cash jobs. And that was a necessary part of passing the Bill of Rights compliant legislation, which the Bill of Rights vet actually agreed with, and was done by the minister, in that case, who's the Minister of Revenue? Parker, is it?
Stuart Nash, isn't it?
Is it Stuart Nash? Sorry, you're quite right. It was agreed by the minister that was necessary for the overall policy to be enacted. And I just don't really quite understand the public relations of this equivocation. It might be they've got a sophisticated piece of legal advice, like Eddie has said, as Ness has said, you need to have a search warrant. There's other stuff we can search with on the phone, which will give us pretty much the same information as the COVID app. Therefore, we don't need to protect the COVID app, because if we can get a warrant, we can look at all the other location services stuff that's on the phone. And like they can look at my Strava, for goodness sake, to see my epic achievements on the mountain bike tracks. But they don't need to look at my
Look,
COVID.
I hope you're not on motorbike tracks. Is that in compliance with the alert level?
Did you drive your electorate van to the?
I've not been on a
track?
bike. Although I did notice that one of the things is that it took a couple of days for people to get back on their bikes on the tracks that are still open around my house. That's certainly not at Macro. I haven't been down Macro Peak, no, yes, which is.
That's good to know. You wouldn't want to be making.
I'd obviously be a trespasser if I was, but I think that's really important. So, what do you think will happen here, Andrew? Do you think that they'll keep up with, what will they do in this compulsory legislation?
Yeah, so it's going to be interesting to see what happens later this week. I'm waiting for Public Health Order number 10 to basically say what the rules are going to be. There's questions about, who is actually going to be enforcing this, the mandatory record keeping, and to what extent is there going to be any leeway. I very much empathize with the concern that you don't want a young retail worker in a cafe having to deal with somebody who is really not wanting to scan and will provide their contact details. That's just not a position that we want to put them in. That's actually just the opposite of the duty of care that we owe them, right? But on
the other hand, to be honest, Andrew, and I used the example I might have talked to you before, is you walk up and down Courtney Place, past all those bars and other entertainment establishments, which obviously we wouldn't visit ourselves, but we see there's some very large gentlemen standing outside as bouncers. And I, for the life of me, can't see why we wouldn't want to make them responsible for saying, why not scan when you enter this establishment?
Yeah, and where venues actually have those systems in place already, they absolutely should be doing it. I think that's one of the reasons why it's slightly incongruous that supermarkets are being left off the list, because they've already got all the infrastructure that is necessary to enforce mandatory record keeping, yet they've been left out because the government says that people can wear masks instead. And that's actually two separate things rather than serving the same purpose.
And on the basis, I think that there's lots of small businesses in retail, which I think Woolworths, Countdown, and Foodstuffs probably don't count as small businesses.
Yeah. So what we've got, we're kind of talking about Parliament, Eddie, and we're kind of talking about lawmaking. So that's your area of expertise. What's going on in Parliament? Like, the big show in town at the moment is not Parliament. National and ACT really wanted it to be going on, apparently. Although it's not clear what they would have done, push come to shove, had their bluff been called. But what's going on? And is it good or bad?
I'll show my deep expertise on Parliament, by the way, by correcting myself and saying that you were entirely right. I was in a time warp back to the last Lowdown on the lockdown when Stuart Nash was indeed the Minister of Revenue. But you were correct the first time, David Parker at the moment. But what's happening with Parliament is, this is quite an important distinction. It's an incredibly nerdy train spotty distinction, but it's quite an important one. Parliament has not been suspended. That would require the Prime Minister to go to the Governor General and have it prorogued, which is not something that has happened in, I think, 30 years in New Zealand. What is happening is that the House is not sitting. So the reason that's important is that what can still happen if the House is not sitting but Parliament is in session is that select committees can sit. And we are having select committees sitting virtually and hearing evidence from ministers and from senior bureaucrats in a way that they probably wouldn't in any context other than the financial estimates, where people turn up and explain themselves once a year. So there's certainly access to opposition by opposition MPs to decision makers, both ministerial and in the public service. And that's a good thing. The nerdiest television viewing in the world, it's all being broadcast on Parliament TV. So you can watch that if you want. I think the Health Select Committee is back this afternoon. In fact, I think as we speak, as we're recording, it's live. So all of this attention is happening. But the House isn't sitting. And neither do we have something like the Epidemic Response Committee that we had during the first lockdown, which had this sort of overarching overview of what was going on. and had representation from all parties in Parliament with an opposition chair. And I think none of the important committees that are sitting at the moment happen to have opposition chairs. There are a couple of opposition chairs, but not in the committees that are doing the heavy lifting at the moment and asking the questions of these bureaucrats. So there's a question about whether there should be something like the ERC, or, and I see that this is something that Chris Hipkins mentioned at the press conference today, working out with the Speaker and the Business Committee how potentially to have the full House sit in a virtual context. One might have thought that they would have some thoughts about how they might have done that over the past 18 months. But as Dean said, I suspect before Delta arrived, people didn't think we'd be back at level 4. And they may have been caught out a bit on the mechanics of this, both the Business Committee and the Speaker's office. But we'll see, depending on how long this extends, we'll see what those groups, both the Business Committee and the Speaker, can do to have the full House sit via Zoom or some other platform.
Yeah, no, I think there was some really interesting political writing last week about the game that was being played by both the government and the opposition in relation to whether they really wanted Parliament to sit and whether who were trying to force who to make the move. So that it seemed very clear the opposition was keen to make the government make the move for political reasons, but also to have the ERC. But it was unclear too that the epidemic response committees, we know, was a mixed blessing for the last leader of the opposition. On the one hand, he did really, really well and got a lot of praise for the first couple of weeks of it, and then not so much. And so it's a bit of a high pressure environment given the current politics, I suspect, of what you might want if you're the government and what you're the opposition. And what we've got at the moment, as the Prime Minister has said, seems to be an environment where in fact you can ask more questions of ministers, but you don't get that kind of the same kind of confrontational got-you questions that Question Time gives you. So perhaps we've probably been going for a while. Dean can start us off. We just, at the end of these sessions last time, just said a couple of lines about what we all thought we were looking out for next time. Just to go back to Dean, what are you looking for in the next week, Dean?
I'll be refreshing the legislation website, looking for new COVID orders, amendments to COVID orders, and possibly, and maybe next time if we get a chance to talk about it, any tweaks to the Section 70 orders are being issued in relation to people who are at places of interest as well. So we've still got the dual regime going on there, but I'm going to keep an eye on the rules and how they're being sharpened and whether the policy settings change into a level 3 or something like that, which raises a whole different set of dimensions.
And Nessa?
I'll be keeping an eye out. I'm going to dig out my notes from last year and see what the level of charging was by the police. And I think also seeing if it goes on much longer around the court hearings, because they're very restricted at the moment, even restricted them more from Delta, so we tend to get a bit of a backlog in jury trials. So, and also I'll be glued to what the health order is for the mandatory record keeping and the parameters of that.
Andrew, you're obviously pretty keenly looking at the what the law might actually look like.
Yeah, on the mandatory record keeping, both what the rules are and what the guidance is going to be, because I think that's going to make a big difference in terms of how it's actually practically enforced by those businesses and what the burden is actually going to be for them.
And Eddie, what's your hot tip?
I'll be looking, just as I mentioned, at whether we end up getting some sort of infrastructure, digital infrastructure for Parliament to sit, and also just looking at that guidance versus compliance interaction and whether we have people start getting sick of wearing masks in public and whether a heavier hand ends up being needed in some areas.
And I think for me, I think the really interesting theme is going to be the degree to which the retooling of policy can go on, because I think Dean alluded to this, that clearly we were in a different phase. Monday last week, we were all on how we're going to reopen New Zealand, and now we're in the Delta phase. And so there's a lot of policy to be retooled. And I'll be interested to see what else is going to come out of government in terms of the policy that they were going to use when they were reopening and how that gets retooled, I suppose, for this new Delta environment. I suspect contract chasing is only one part of that. Mask wearing is only one part of that. There must be other stuff that they've been thinking about in government, which maybe they were worried about talking about, or they've not necessarily developed hard enough, or maybe they thought was impermissible given New Zealand's human rights settings or predilections, that might be more discussable or more contestable given Delta. Because I think Delta has changed things. People do seem to be accepting at the moment that Delta is COVID was a very real threat last year, but somehow this seems a real threat plus. And I'll be interested to see how the government responds to that threat, and also what New Zealanders are going to accept in relation to that. I think last year, if we'd arrested protesters in the way we'd arrested the people that were arrested, there would have been outrage. There was no outrage this time, maybe because of who was arrested, but also just because people accepted that really that's what needed to be done. So that's what I'm looking forward to. But if those of you who have made it so far through this, I think we're going to come back and do some version of this next week. And hopefully we'll get Andrew back, and if not next week, the week after, talk about what the law actually looked like. But thank you for following so far, the continuing saga of the law and Delta and COVID and all the rest in New Zealand for us to follow. So thanks a lot.